A Kansas courtroom erupted into pandemonium as grieving families traded punches during the sentencing of a teen convicted of killing a 14-year-old boy. What was meant to be a moment of justice spiraled into a full-blown melee, caught on camera as emotions exploded just feet from the judge's bench. I'm going to be breaking down what led to that explosive moment in court, the case behind it, and what comes next for everyone involved. Welcome to Sidebar, presented by Law&Crime. Jesse Weber. Hey, so look, I know you guys might be interested in true crime and legal stories, but a little side note here, is anybody also in a business of some kind? If so, let me tell you real quick about Odoo, our sponsor. Odoo is a powerful all-in-one business software that helps you manage everything from sales to accounting and, yes, inventory. Their inventory dashboard makes it easy to track receipts, delivery orders, POS orders, and see what's waiting, late, or back ordered all at a glance. You pay for receipts, you automate vendor reminders, and you schedule deliveries all in just a few clicks. Plus, you get full warehouse management, the ability to set picking strategies, and real-time stock visibility. The best part, Odoo's inventory app syncs seamlessly with your sales and e-commerce apps so everything stays connected. Do you want an inventory software that comes fully packed? Well, check out Odoo for a free 15-day trial at odoo.com/sidebarinventory. What began as this emotional sentencing hearing for a teenage killer dissolved into this violent courtroom brawl last week. Punches being thrown between grieving families, deputies struggling to restore order into the courtroom. It was absolutely insane. This chaotic scene, captured on courtroom video, unfolded April 8th inside of a Kansas courtroom after Jeanette Dees pleaded with a judge to give her 14-year-old son's murderer the maximum possible sentence. And this is what went down inside that courtroom.
I'm not saying that we're innocent, but you know what I'm saying? I hate him, and I hope something bad happens to him in jail. I hate him. And I think that you could consider, you should give him the max that you can, because evidently he don't care.
Now, moments after her emotional statement, that's when tensions erupted. You can see deputies stepping in to escort people from the gallery as shouting breaks out, and then the first punch is thrown. And actually, let's take a closer look at how the chaos unfolded. So in seconds, the courtroom descended into violence. Officers rushed to break up the fight. Multiple family members from both sides got involved. One woman can be seen lifting a baby from a stroller, get the baby to safety as this chaos spills across the room. Even the victim's mother, Jeanette Dees, who I mentioned before, was allegedly seen physically engaging in the scuffle and even maybe allegedly spitting at the attorneys. Now, at one point, a sheriff's deputy can be seen asking a woman, "Is your baby okay?" Again, a haunting reminder of how far this chaos had spread. So what on earth led to such an explosive scene? Well, I'll tell you what, this was the sentencing hearing for 19-year-old TrenJ'vious Robinson, and he was being sentenced for the March 18th, 2022 shooting death of TrenJ'vious Hutton inside of Wichita's Town East Mall. Robinson was a minor at the time of the shooting, but he was sentenced as an adult. And we're going to get more into the case and the details in a minute, but first, I want to talk about what we saw erupt in this courtroom. So I want to bring on Allie Young, a practicing trial attorney out of Kansas City, Missouri. Listen, Allie, thanks so much for coming here on Sidebar. I believe this is your first time on Law&Crime, so happy that you get to be on Sidebar as the first time you come on.
Thank you.
This was something to see. I mean, just your initial reaction to seeing something like this in a courtroom.
Yeah, it's shocking, and you hit the nail right on the head when you're seeing a woman have to struggle to pick her baby out of a stroller amidst all of the chaos and the violence that's going on. It really makes you take a step back and really take a look at what's going on in the courtroom at the time. It's not unusual for tensions to be that high in a courtroom. It's not unusual for anger and frustration to be there from all sides, whether that's the victim side or the defendant side. But it is unusual to see a massive brawl like that just erupt instantaneously almost.
So do you see things like this happen? I mean, maybe not often, but in your experience, have you personally seen something like this? I know we've had episodes before where sometimes you'll have a defendant attack his attorney or attack the judge, but a brawl like this This is what deputies are hoping doesn't happen every day.
Here, I haven't had one personally happen to me, but I've seen it in the courtroom when I'm waiting with another client. It's something where judges and bailiffs and their court staff are very aware beforehand that something like this could erupt, and they bring in extra sheriff deputies to come in and to hopefully allow their presence to kind of calm the situation before it starts. And it looks like that kind of was the situation here, where they had several deputies on hand. It's not normally the situation to have several law enforcement officers in a courtroom at one time. So I imagine here they were anticipating some sort of outbreak like that.
And when you think about it, look at the victim in this case, TrenJ'vious Hutton. He was 14 years old when prosecutors say he was gunned down inside of a mall by then 16-year-old TrenJ'vious Robinson. So you're thinking about the gravity of this crime. And, Allie, from a courtroom management perspective, what typically goes into preparing for these emotional moments, these emotionally charged sentencing hearings, for example, especially in murder cases? I remember when I was in the courtroom for the verdict in the Harvey Weinstein case, there was more courtroom personnel than I had ever seen because nobody knew what was going to happen. And there was so much at stake. So when you have a sentencing hearing like this, when you know emotions going to be running high, what are some of the plans that are put in place?
As for the defense side, I mean, we sit our clients and their families down, whoever is going to be attending, and we sit down and we have those conversations that frustration and anger, that's appropriate. And we understand that that's coming from a place of love and a place of them being scared for their loved one. But the expression of frustration and anger and that would lead to violence can only do harm to their loved one as the defendant. So while we understand those frustrations with the system sometimes, there's a proper place for that frustration, and in the courtroom is never going to be the place to air those grievances, especially if it's going to be in ways of violence like this. Then, like for a court staff, they are aware of tensions that are going to erupt. They are aware of sensitive cases that are on their dockets for today, and they will alert the sheriff for our county. They will alert the sheriff to have extra presence there in case something does erupt. Overall, as a whole, that's a conversation that has to happen between the defense attorney and whomever's going to be there during the sentencing, that in order to kind of protect their client in the best possible way, everyone has to be on their best behavior, because it can only, the judge only has power over that one person, and they certainly can exercise power in a way that puts down the effort of violence, if that makes sense.
It does, and we're going to talk about it a little bit later, but you're looking at people who are hit with disorderly conduct charges. Were there more serious charges they could be hit with in something like this that they could be facing? And could a defense be, hey, listen, emotions got the best of me. I know it was wrong, but look what I'm dealing with. I shouldn't be charged, or I should be found not guilty for this. Anything we should be thinking about there?
They absolutely could be charged with more serious offenses: endangering the welfare of a child when there's a baby right there, assault, battery in Kansas. Those are all charges that are very applicable here. And I think, just from watching the video, I think they're lucky to have received only the disorderly conduct charge, which is a C misdemeanor in Kansas. So it's a low-level misdemeanor. I wouldn't say there's necessarily defenses that are applicable, whereas we use the word defense to say somebody's not guilty of something, but there's a reasoning for it in a sentencing. If you get that far where you're saying, hey, this is why this is happening, there's a justification for the action, and it can obviously produce some leniency by the judge depending on what the justification is. In this case, sure, there's absolutely a justification for it that we would see a defense attorney present, but it doesn't necessarily make them not guilty of it.
That's fair. That's fair. So let me just lay out a little bit more of this story to give everybody a full perspective on what happened in that courtroom. So on March 18th, 2022, police say TrenJ'vious Robinson opened fire inside of the Town East Square Mall in Wichita, Kansas, shooting 14-year-old TrenJ'vious Hutton multiple times after a dispute turned violent. According to reporting from KWCH, one witness who was shopping at the time said that this altercation began with yelling and pushing before the gunfire started. Told the station he heard 2 shots and then another 5, sending terrified shoppers running to cover. You had another witness, a mall employee, said that he was near the entrance when he heard the gunshots. You had a second employee who recalled helping customers hide inside of his store. And the chaos was so intense that a 911 caller reported what they believed to be an active shooter situation. But when police arrived, they determined that was not the case, but rather this was a targeted incident, reported as possibly gang-related. Now, in a July 2023 hearing, one of the lead detectives testified that Robinson told her the victim had pistol whipped him during the confrontation, which Robinson claims triggered the shooting.
Exactly what he told you happened, that he was involved in a fight, that Mr. Hutton hit him in the back of the head with a firearm, and then he shot him, correct?
Correct, so that can be viewed for those, yes. And he fired 3 rounds at an individual he knew as Mac N, which we will later learn to be TrenJ'vious Hutton. And then as he left the mall, he dropped his 30-round magazine in front of round 1, and he picked it up and then left the mall.
Now, Robinson also told investigators he was with another minor, a 17-year-old at the time. And both teens at the beginning were arrested, though KWCH reports that that 17-year-old was later released. Robinson was arrested initially as a juvenile, but shortly after, his case was transferred out of juvenile court, only to be later refiled in juvenile court in June of 2023 due to a records issue. This is again according to reporting from KWCH. And in a pivotal hearing that July, a judge reviewed body cam footage, Robinson's police interview, heard testimony from detectives before deciding whether he should be tried as an adult. And KSN reports that in January of 2024, the ruling came down. Robinson would officially face charges as an adult, first-degree murder and criminal use of a firearm. So what happened next? Well, what happened next would shift the trajectory of the case and the charges, and we're going to get into that in a little bit. But Allie, first of all, what are the factors that typically influence a judge's decision to transfer a juvenile case to adult court in your state?
So when we're looking at what's called certification, it's the process of transferring a juvenile from juvenile court into the court of general jurisdiction. So big boy court, if you would. A judge looks at several factors, and most notably in a case like this, you're going to look at obviously the severity of the offense. This is the most severe offense that you could possibly have in any court, whether that's juvenile court or that's the general jurisdiction court. They're going to look at whether or not the state has the amenities available to that juvenile to rehabilitate them. A juvenile court focuses very heavily on rehabilitation as opposed to the punishment and retribution that the general jurisdiction court does, adult court. And so they're looking to see, do we as a state have any resources available to this juvenile that they can utilize that would benefit them, that could put them back into society. So in Kansas, a juvenile can only be in the juvenile system until they're 22 and a half, and then they get kicked out. So there's not a whole lot of time if somebody's 16, 17 years old already for them to start that rehabilitation process. So that's the other factor that they look at is how old is this person? Can they be rehabilitated in that amount of time? There are programs that are about a year and a half long, but it doesn't give the juvenile court a whole lot of leeway if they're not following the program to a T once they get into that juvenile program. So those are some of the main just categories or factors that a juvenile judge would look at while they're in certification. There's a Supreme Court case that talks a little bit about what certification should focus on, and while the crime itself is a factor that the judge should focus on, the juvenile as a whole is what the judge should put the biggest stock in, whether or not they can be rehabilitated and whether or not there are adequate programs in the system for that juvenile.
Let me ask you this. Do you think that it was appropriate, given the circumstances of this case, for it to be transferred into adult court? And the idea that Robinson allegedly claimed he was pistol whipped before firing, valid self-defense argument?
Two things. I do believe that this is an appropriate case for transfer to general jurisdiction. If there's not a case that is appropriate, then I don't know what it is, if it's not this one. Because if we're looking at murder in the first degree, then there's not a whole lot of rehabilitative programs that are going to be available to a juvenile at that point. But if you are then talking about whether or not the juvenile or the adult has a good self-defense claim that is available based off of his statements, yes, you do. But then the other facts of the case, you start to look at the other facts and you kind of have to make that determination as to whether or not that's a viable claim. But in Kansas, there's an interesting immunity hearing that you get to have once you're in general jurisdiction. And so that's kind of the benefit of being transferred from juvenile court into adult court, is that immunity hearing where the judge can decide if there's probable cause that the defendant did not use self-defense in a reasonable way.
Yeah, and clearly, I'll get to the conclusion of what happened here, but it doesn't sound to me like that would have passed the muster here. You think about this case, because let's talk about it. I mentioned earlier that he was initially charged with first-degree murder, criminal use of a weapon. Last July, he ended up entering a no-contest plea to second-degree murder, attempted murder, and aggravated battery. KSN reports that he later tried to withdraw that plea, and that was a request the judge had ended up denying. What was the reason, Allie, you think, behind entering a no-contest plea instead of pleading guilty? I think a lot of people also wonder, by the way, as a point of law, is there a difference between an Alford plea and a no contest plea? I know I'm throwing a lot of questions at you, but I was asked that the other day and it was an interesting question. So I guess what's the advantage here of entering a no contest plea?
So in general, a no contest plea he's not admitting any guilt at all. He's just acknowledging that there's enough evidence that could find him guilty. Later on down the road, if the victim's family files a civil suit, or if there was one already filed, they can't use this criminal case against him in that manner or in that civil suit. So it gives opportunities in that way. It also allows for a plea bargain to happen without there being an admission of guilt. And so that's what we see here.
Do you think it's unusual for it to be downgraded from first-degree murder to second-degree murder as part of this deal?
No, I think it's a very usual situation to have happen. I think it's a plea bargain that looks at both the weight of the evidence and the fact that a jury can get involved, and juries do tricky, squirrely things all the time. And from the state's perspective, this is a great result because it holds somebody accountable, and he obviously got a significant sentence involved. But then for the defendant, it's a great result because he was in control of the sentence that was handed to him through that plea bargain. And two, his charges were reduced to where he didn't have to face life in prison with the possibility of parole.
I don't know this for sure, but the idea here that he maybe wanted to withdraw his plea and that was denied by the judge, I don't know for sure. What is that, buyer's remorse? I'm thinking about it now, and I'm like, I don't know, or unless there's something else that I'm not understanding. With the withdrawing of the plea was interesting.
You know, when I was looking at this case, I was doing a little research on the Odyssey web engine, which is the Kansas website for courts, and it did have a letter that the defendant had written the judge, and it just talked a little bit about that at that a previous hearing, he was not in a good state. He was dealing with some family issues, and he wanted the opportunity to go back and change his guilty plea. I don't know. It didn't go into much more detail. I don't have the benefit of knowing.
Sure.
But it's not an uncommon thing for there to be letters written to the judge saying, hey, I want to withdraw my plea. That's why they go into such great detail, and there's a plea petition that is pages and pages long, and the judges do a long, extensive plea colloquy, making sure you understand your rights, making sure you understand that this is binding and you can't go back on it. Once you enter into that plea agreement, then you're there, and we're doing this, and there's no second thoughts.
Yep, that's why it's so important to know what they're signing on to. So you get back to the sentencing here, and goes back to that brawl that we started the episode with. So on April 8th, Robinson appeared in the Sedgwick County Courthouse, and just before the sentencing, the victim's mother, Jeanette Dees, spoke to the judge. And according to the New York Post, she directed some sharp words, not just at Robinson, but apparently at his family and friends in the gallery. That sparked a heated exchange. Insults, gestures, those were flying. And then suddenly, a fist was flying too. In seconds, the courtroom became a battleground. Multiple people from both families throwing punches, grappling as deputies, and even Dees herself tried to break it up and jump in. The judge cleared the courtroom, ejecting several people before finally sentencing Robinson to 21 years and 3 months in prison. So that's 255 months total in prison. But the fallout was just the beginning, because by May 1st, the Sedgwick County District Attorney had filed disorderly conduct charges against 6 people. Jeanette Dees, using fighting words, that's according to an official release from the Sedgwick County Sheriff under a particular Kansas statute, a charge that's defined as using fighting words or engaging in noisy conduct likely to arouse alarm, anger, or resentment in others. Derek Parker, a relative of Hutton's, TrenJ'vious Hutton, TrenJ'vious Hutton, a 16-year-old boy. The others are all charged with disorderly conduct that falls under another statute defined as brawling or fighting, and all were accused of either brawling or inciting violence. These are, as we talked about, misdemeanors, punishable by up to a month in jail, $500 fine. So, Allie, first let me ask you about the sentence of 21 years for Robinson. You think that's appropriate in the end? After we talk about the whole brawl and everything, going back to the sentence here, you think 21 years is appropriate?
You know, as a defense attorney, it's hard to say that a minor, I mean, he's still a young child, 21 years, he'll be almost 40 years old by the time he gets out of prison. It's hard to wrap your head around and say, yes, that's what is appropriate in a case like this. However, when we have shootings in very public places where there are so many bystanders that can be affected in ways that are negative and harmful, a judge in a county has to send a message saying that we are not going to tolerate this type of behavior. It's one thing to it's one thing to be brawling. It is one thing to be fighting in the mall. It is one thing to even just have the weapons. But once you are discharging those firearms and you are using them in a capacity that can hurt and kill lots of individuals that are not even part of the brawl, then I think we enter a different discussion where, yes, that can be a very reasonable sentence.
And real quick, before we wrap things up, you mentioned how they're lucky, the people who were involved in this brawl or allegedly involved in this brawl, to be hit with disorderly conduct. Very interesting how they were charged, particularly Miss Dees, right? The idea of fighting words. That's interesting.
Yeah, so I imagine that part of her charge comes from her emotional speech to the judge.
Yep.
When you're giving victim impact statements, they're always supposed to just be directed to the court. They're not supposed to be directed to a defendant. They're not supposed to be directed to attorneys, anyone in particular. It's only supposed to be to the court and how this crime has impacted you specifically. Once you turn your attention away from the court and you start calling out family members that are in the gallery, those are fighting words. Those are words that are inciting violence, and they're not appropriate. They're obviously not legal in the state of Kansas because you're inciting violence, and it can't be tolerated, is what the Sedgwick County is saying.
Allie Young, thank you so much for coming on here on Sidebar. Really appreciate it. Will you come back? Another case?
Yes, absolutely.
All right.
Absolutely. Thank you so much.
I'm glad I didn't scare you away. Thank you so much for taking the time. Really appreciate it.
Yeah, you have a great day.
And that's all we have for you right now here on Sidebar, everybody. Thank you so much for joining us. And as always, please subscribe on YouTube, Apple Podcasts, Spotify, wherever you get your podcasts. I'm Jesse Weber. I'll speak to you next time.